All righty. Good morning, everybody. Thanks for hopping on to this month's Industry 30. Pleased to introduce our speaker today, Andrew MacDonald from Fox Rothschild. He's going to be presenting on what unionized contractors need to know about the changing legal landscape. This presentation is being recorded and will be placed on the chapter's website. And you do have the ability to unmute yourself to ask any questions. I just recommend please save those questions at the end of the presentation. If there's anything urgent, just use the chat feature in the Zoom program. With that being said, I'm going to turn it over to Andrew. Take it away.
Good morning, everyone. Thanks for attending. I'm Andrew MacDonald. I'm a partner at Fox Rothschild in Philadelphia. We're going to talk about employment law, labor law. What I've tried to do this morning is customize these slides, this presentation, for contractors in this industry, contractors who are NECA chapter members, contractors who have union employees, because sometimes you'll get a presentation that is not entirely tailored to your line of work. It may be very general about employment law or labor law, and might not necessarily fit a contractor like yourself that's part of what I would call a stable labor relationship with the various IBEW locals, and have real mechanisms set up, committees and divisions, and you have your negotiations handled. It is a very different world than what I would say is happening in other industries, or even some other parts of the construction industry, where you're seeing a lot of news coming out about various strike actions, like the UAW strike, labor relations at Amazon, things of that nature. So, those issues are not going to be relevant to you necessarily. So hopefully the things that we'll talk about today will be relevant to you. And you can put any questions in the chat, and Rob and I will make sure to get them answered. Now, you'd think I would have it figured out by now, but I'm having a little issue with my slideshow, and I'm not really quite sure why it's not working as normal. So I've just kind of expanded the slides, and I'll push them forward, and we'll go from there. One second. All right, so here are the topics today. We're going to talk about the Department of Labor proposed, and I'll talk about what that exactly means earlier or later, salary minimum overtime rule, because this is going to affect all employers, whether you are union or non-union, and it's especially going to affect employers like I imagine many who are attending this morning that have, office employees, employees that are either non-union or not in a trade, and that this rule is going to especially target those office employees, and could have a profound impact, major impact, based on how much those people are being paid and what kind of work they're doing. I'm going to briefly talk about Davis-Bacon regulations. There is a regulation that was issued this fall, largely does not impact most of the people who are attending this program, but there are a few aspects that might. So I'm going to talk about that. I'm going to give some updates about recent developments at the NLRB, the National Labor Relations Board. That is the body that oversees federal labor law, where unions and employees take their disputes against employers. And those updates will be, like I said before, really attempting to tailor some of these developments to things that would be relevant to you and not just employers in general. And the last thing I'm going to talk about is withdrawal liability, as that term is related to pension funds. And when withdrawal from a pension fund is triggered, what that means, and what the exemption for construction employers really means and what it is kind of contained to. All right, so first up is this is a proposed regulation by the Federal Department of Labor. And the most important takeaway that you could have today about this Department of Labor rule is to know that it's proposed. It could be issued shortly, but it is not in effect yet. So no one should be going around changing things just because there may be a possible regulation, but you should also prepare for it. And I'll talk about what exactly those preparations could entail. So this is a proposed regulation. If you remember, and I had presented on this, I don't know, I guess it was a year and a half ago, maybe 2 years, the OSHA vaccine mandate. That was a regulation that was pushed out immediately because they claimed there was an emergency basis. The Department of Labor here is not pushing this regulation out immediately. So it has to give notice to the public of the actual regulation, not just the topic. It has done that. It has given notice of the proposed regulation as it would be written, along with commentary. The public, which means employers, think tanks, politicians, anyone, has the right to file comments to this proposed regulation. The DOL can consider those comments, can change the regulation based on the comments, and then issue it, legally promulgate the regulation sometime in the future. The 60 days for the minimum comment period will run in a few weeks in December, but agencies regularly sit on these after issuing proposed regulations for months at a time. So I don't think that it will be issued anytime soon, but it may be. Also, it may be subject to a court challenge before it even starts. There could be an injunction. As an example, there is still a Obama era labor management disclosure law about how labor persuaders, labor consultants, people who are employed to dissuade employees from joining unions. There's a regulation that has been enjoined since, I don't know, 2014, 2015. So sometimes if an injunction is issued by a court, and it can be a random court, any federal district court, then it could sit for some time. So with all that, let me tell you what the proposed regulation, where it comes from. So the law on basic minimum pay, overtime, things of that nature is from the federal, it's not a state law, it's the Federal Fair Labor Standards Act. That's a New Deal era law passed in the 30s, and it is administered by the Department of Labor. The Department of Labor issues regulations under this law to add to the text of the actual law, clarify what some of the parts of the law means, and they have issued those regulations for decades. Two important types of regulations say for people who are exempt, and you may have heard of this term before, exempt versus non-exempt. Non-exempt is an hourly employee. Exempt is someone who is exempt from this law and is able to be paid not hourly, but on a salary basis. And to qualify someone, they have to be doing certain kinds of duties. So administrative duties, not manual labor. And they have to be paid a certain per week amount of salary. And that is a salary payment that does not depend on how many hours they work that week. It is a set amount with few exceptions, 40 hours of work or 50 hours of work. So you have to have both in place. And what the DOL does is set a minimum level, and it is proposing to raise that level. So right now, if you have an administrative employee who is exempt, so they're performing non-manual work, they have some level of independent discretion to do their work, I would say think office administrator versus receptionist. Right now, as long as you pay that person $684 per week, that's around mid 35,000 a year. That person could be exempt today. If this regulation goes into effect, that's going to jump up to $1,059 per week. And that ends up being around 55,000 a year. So as you can imagine, if you have someone who's making $40,000, $45,000, $50,000, they are your office administrator. They are paid on a salary basis. That person would no longer, unless you adjusted the salary, be able to claim that exemption. That person would automatically become an hourly employee. You would have to track that person's time. You'd have to adjust possibly how you track that person's time, timesheets, etc. And then if you see the note at the bottom here on this slide, the regulation would have an automatic escalator based on inflation every 3 years. So that 1,059 would go up automatically every 3 years in line with inflation. So this is something that, if it goes into effect, will be a constant adjustment, making sure your people who are exempt employees, think office workers, are making the minimum amount at least to qualify for that exemption. So, and this is true whether they have the same duties or not. So what would you have to do is, like I've kind of been mentioning, but you may need to restructure a job. If that person's going to become an hourly employee, maybe you give them different job duties, combined jobs. You're going to have to adjust budgets. Think about this increase every 3 years that you have no control over. It would be set by a law or a regulation. And, if you don't take action, if you don't fix or plan on to meet this exemption, then it could be some quick, easy lawsuits. If you have a number of office workers that this could affect, it could become a class action lawsuit pretty quickly. Wage claims like this are generally not insurable, so this would be something that's not covered by your insurance, and it could be a headache to deal with. So stay tuned. If this goes into effect, we can make sure we push out an alert to chapter members. For now, there's no immediate action, but just planning would be the proper step. Okay, so that's the DOL proposed regulation. I'm going to do a quick note here on Davis-Bacon. So the Department of Labor, same body that put out the proposed regulation for the Fair Labor Standards Act, they also oversee the Davis-Bacon Act, and they issued a regulation. It is not a proposed regulation, it's an actual regulation that went into effect. So the main thrust of this regulation is to change the way that the Department of Labor calculates rates for prevailing wage Davis-Bacon projects. And it is complicated. There is this 30% rule. You may have heard that before. And it is a way that the department gathers information about how much a certain trade is paid in that area, the quote prevailing wage. None of that really applies to anyone who is subject to a collective bargaining agreement, though, because the main source of information for the DOL to cite the rates or to fix the rates is to look at the collective bargaining agreements in the area. So if they are looking for how much a heavy equipment operator makes or an inside electrician, they are going to look to the CBA, the applicable CBA, and set the rate. So you don't really need to worry about that. This regulation is a good thing for union contractors, because what it is going to do, especially in any area where there isn't a super high concentration of union labor, it is going to generally increase the prevailing wage rates to get up to the level where union contractors already are. It's going to level the playing field. The NECA National is very supportive of this regulation. Now, as you can imagine, though, when the government is issuing a regulation and it's hundreds of pages long, there are other provisions that have nothing to do with what the main point of the regulation is. So some things that are stuck in these regulations are two things that I think are important for this crowd here this morning: an anti-retaliation provision and an expanded definition of who a contractor is. So anti-retaliation is important because if you are working on a prevailing wage job, doesn't matter if you're a union contractor, non-union contractor. As of today, it is very unclear how a employee with a complaint about prevailing wage should bring that sort of claim. Davis-Bacon itself is not a lawsuit that not a law that a employee or a union is allowed to file a lawsuit over. It is not like the FLSA, which says if you pay someone less than the minimum wage or don't pay them overtime, they can sue you. Davis-Bacon is enforced by the department, which makes it somewhat clunky, and it's subject, you have to have a DOL investigator come out. There are ways in which unions and employees can bring Davis-Bacon claims, but they are not easy. What this regulation does is say if someone makes a complaint about their prevailing wage pay, and then you take some sort of action against that person, terminate, demote, fire, transfer off the prevailing wage job, it could be any number of things, then that person can go to the Department of Labor and bring their own little action against you within the Department of Labor. So that's giving employees an avenue that they don't currently have. And I think it's important because it is something that would not necessarily be subject to the collective bargaining agreement, grievance procedures. This is something that you might have to deal with from an individual, even if the union doesn't support him, even if there's no grievance filed. They have this new individual right, which could become a pain if someone is trying to protect themselves and makes a complaint before they get demoted or fired. And it's just something to watch out for. So, generally, if someone comes to you with a prevailing wage complaint, they're not getting the prevailing wage, you should always take that seriously. Make sure someone is getting the proper amount of pay. For any federal job, you do not want the DOL auditing you anyway. But now there's another avenue of attack here for prevailing wage jobs. The other issue is that the regulation has a new view, an expansive view of which kinds of companies can be brought together by the DOL if they are auditing a company, if they are taking some sort of action against a contractor. And the DOL is trying to loop in anyone who's a joint venturer with the targeted contractor. This could include prime contractors, general contractors, owners. It could ensnare your business into someone else's dispute, or it could also bring you headaches if the general contractor or the owner gets dragged into a dispute that you have over prevailing wage. So that's something to look out for. You may be seeing adjusted language in contracts too, just construction contracts, to try to make sure owners and general contractors will be trying to make sure that you bear that kind of liability in case they get dragged in. Something to look out for. Okay, so we're going to move on here to NLRB, that's the National Labor Relations Board developments. There have been a number of decisions, at least 10 to 15 that I can count off the top of my head in the past year, that have really changed some aspects of federal labor law, including a brand new election rule, which probably won't apply to anyone who's in this room because you don't have no need for an election. You already have a union. But it is a dramatic change in the way that elections are handled. It basically makes the employer file for the election if a union or a group of employees come and claim to represent a majority of the employees. Again, people in this webinar probably won't need to worry about that. So I'm going to talk about some other recent developments, updates that have been coming out of the labor board, including handbook rules, what counts as protected activity, how employers handle picketing, sympathy strikes, and another proposed rule, like the first one I talked about, this one about a joint employer concept. So the NLRB in early August issued a rule or a ruling. So they issued decisions, not generally regulations. So this is a case. It came out of actually a Philadelphia area shredding company, a case that was filed way back in 2012. The labor board finally issued a decision on it this August. It had gone up and down in the courts for a while. And this rule applies to all union and non-union employees. So office employees, field employees, union employees, anyone who is not a supervisor is covered by this rule. And what it seeks to penalize are mere rules written down in a handbook. So the labor board would say this rule in this handbook or work rule or policies and procedures book is unlawful just for being a rule. No one needs to be disciplined. There doesn't have to be a termination, no written warnings issued to anyone under this rule. Just the fact that it exists is a problem in the eyes of the labor board. And they have created a test, which I've quoted some of it here because it is a departure from prior precedent. And what they're going to do is if they want to target a rule, they being the NLRB, they are going to see, does this rule have a, quote, reasonable tendency to chill employees from exercising their Section 7 rights? So those are generally their labor rights under the National Labor Relations Act. So is it the kind of rule that could impact someone, make them think twice about exercising their labor rights? And not only are they going to use that test, but they're going to look at this kind of rule through the lens of a, quote, reasonable employee who is economically dependent on her employer. So they're going to look at it through the lens of basically someone who may want to take action. So if you look at a handbook rule, they're going to say, is this the kind of rule that could chill, impact someone's ability to think about whether they're going to take some sort of protected activity, engage in it, and they're going to look at it through the lens of this employee who's, quote, dependent on her employer. So it is an interesting test. It's definitely pro-employee, as you can imagine, pro-union if a union's bringing you charge. It is a test that will ensnare different types of rules. And I'm going to go through a little short list in a moment of what kinds of rules the NLRB does not like. And if it is that kind of rule, the NLRB thinks it could chill protected activity, then the burden goes back to the employer to show that it has a legitimate business interest, basically, in maintaining that rule. It is something that an employer can sit on a witness stand and explain why they have that rule and why it's necessary for the business. And the labor board goes a step even further and says that the employer would need to explain why it can't meet that kind of interest without some other type of more narrow rule. So if you get targeted by the labor board on a rule, you really have to justify it. You have to be able to articulate why you have that rule and why some other type of rule isn't enough, isn't sufficient. So what kind of rules are we talking about? Social media rules which could restrict what someone could say on social media about the company. Civility rules, treat other employees with respect rules. Labor board doesn't really like those rules because it could be wielded against someone who is, say, striking. You're striking outside of my office. I don't like that. That's not civil. I'm going to punish you. So that kind of rule is something the labor board doesn't like. Confidentiality of investigations. The labor board would like employees to be able to talk to each other about work at all times with no restrictions. So what they don't like is if you tell someone, I'm investigating you, or I'm investigating someone else for fraud. I need to question you about how you process this person's receipts, and you must keep this investigation confidential. Don't tell that person. Don't tip them off. The labor board does not like that. They want employees to be able to talk to each other about ongoing investigations. When challenged, the labor board claims that they would, if there are credible suspicions of witness intimidation, that you could have a confidentiality rule, but it's difficult to prove that. Other rules that they don't like, anything that says you can't criticize the company, its products, its services. You can't disparage the company. The labor board does not like that because employees have a right to strike. Employees have a right to say that you're an unfair employer. Employees have a right to say that they don't think they're being treated properly. So that's where that kind of rule restriction on that kind of rule comes from. Safety complaints. The labor board doesn't like highly hierarchical, chain of command rules to bring a safety complaint, because they want employees to be able to tell anyone, including OSHA, or more than just their supervisor, go right up the chain of command, go to the union, go to OSHA, go to someone on the outside without any restrictions. A relatively new rule that's been popping up is, you can't record at work. The labor board has said in multiple cases that employees have a right to record any sort of interaction with their manager on their phones if they want to. So if it's something that's they're given a reprimand, they're given instructions for work, they are witnessing some sort of safety or something they think is a safety violation, the labor board wants employees to be able to record those instances, and has said that employees have a right to do it, regardless of what state law says. And if you need two people to consent to a recording, they don't care what state law says. Federal law overrides state law in general. So if you have a rule that says you can't record at work, it is going to be difficult for you to be able to articulate why you need that. It would need to be to protect trade secrets, to protect, I don't know, the integrity of some sort of process that you do that other employers do not do, and needs to be kept secret. If you are perhaps doing work in a government facility that is a defense contractor, you might win that case because they are the ones restricting you and your employees from bringing in recording devices. But on a general, job site, it's going to be difficult for you to win a case why you should have a no recording policy. So again, these are rules that the labor board just does not want to exist. So an individual, a union can bring an unfair labor practice charge based on the rule existing alone. Again, no one needs to be terminated, and it would invoke a process where you'd have to justify that rule. So that is a new pro-employee, pro-union type of ruling from the labor board that could affect you. So protected activity is another area where the labor board is expanding the scope of several aspects. I'll go through a few of them, of what it means to engage in protected activity. This issue is relevant to union contractors because it's important to note that individuals have a right to file unfair labor practice charges, even if their union is not involved. So even though the union hasn't filed a grievance, hasn't brought the issue to labor management committee, hasn't even doesn't think that the employee is being reasonable or has any sort of legitimate complaint, that employee can always go to the labor board. So when the labor board is expanding what it means to engage in protected activity, it can really affect employers, even if there already is a union in place, even if you have a stable relationship with the union, because that individual can go to the labor board on their own. So protected activity, this phrase comes from the National Labor Relations Act, Section 7, where it gives employees the right to engage in concerted activities for, quote, other mutual aid or protection are the key words. So if an employee engages in this activity that's protected, it is, quote, concerted, generally meaning 2 or more employees. Employers can't retaliate against that person or group because they engage in that activity. You know, if someone's getting fired for some completely different reason, doesn't mean that that individual is protected, so simply because they engage in some sort of protest. But you know, you're going to have to prove that the discharge was because of whatever was going on, performance issues, insubordination, whatever it may be, and not because of the protected activity. And this rule also, I'll just note again, the Labor Act applies to union and non-union employees. We have been seeing a lot of more action from groups that traditionally haven't organized. So, you know, office employees, people of that nature. So, you know, you got to look out for these issues, not just with employees who are already unionized. Okay, so a long list here. I think it could probably be even longer. But what has the labor board done recently to expand what it means to engage in protected activity? So one thing that the labor board has said is concerted. So concerted, like a concert, generally means that there are 2 or more employees engaged in activity. You cannot form a union with one person. So activity has to be concerted. But what the labor board has said, if an individual basically takes it upon himself to act for the group, then that counts, even if he's not working for a group. I'll talk about a specific example on the next slide. So you might think to yourself, well, this can't be protected activity because it's not 2 or more employees. That's not really the golden rule. If that person is trying to induce group action, that could really be enough these days to be concerted in nature. Employee protected activity doesn't need to simply relate to fellow employees within your business. So employees could be advocating for non-employees, for other employees of other contractors, supplier, vendor employees. That counts as protected activity following a recent decision. When you are at the labor board and the labor board is trying to prove that you retaliated against someone, they don't really need any more specific evidence that you essentially retaliated against that specific employee. If they can just show that in some other instance around the time period, you made some sort of statement that showed what the labor board would say animus, you know, negativity toward protected activity or unions or anything of that nature, that can be enough now to prove retaliation. So that's something that could be challenged in the courts, just note. But the NLRB is loosening up what it means to be concerted, who you can advocate as an employee for, how these cases are proved. What they've also done is said they've loosened up the scope of where an employer can push back and say, well, okay, they engaged in protected activity, but they also harassed other employees. It was more than just setting up a little picket line or setting up a protest or, you know, I don't know, gathering with other employees to talk about things. They punched their boss in the face. They stalked someone. The labor board is actually loosening up what kind of behavior employees can get away with. Some recent decisions in the past decade have allowed racist statements to remain protected, racist activity toward strike breakers, general swearing at the boss, something that's less than physically threatening behavior, swearing at a boss on Facebook, calling someone in his family, him and his family, quote, nasty motherfuckers. That did not lose protection of the act. So swearing still protected. And the labor board, remember, they don't like these rules being used against protected activity. So if you say, oh, well, you weren't civil in your protest, you were disrespectful in your protest, I'm okay with you picketing against me. I'm okay with you saying I'm unfair, but you can't say X, Y, or Z. You can't, I don't know, swear, curse. The labor board is going to most likely let those people engage in that activity remain protected. So now you've retaliated against someone because you targeted them for some sort of, you know, you can't curse at me. Last year, about a year ago, the labor board on this last bullet point also expanded what kinds of remedies are available for employees. And so that is anything that is, quote, direct and foreseeable. Now, someone loses their job, they're terminated. What's the direct and foreseeable harm? Well, we haven't had a real case go through the labor board on this yet, or the courts. But we have seen public settlements where an employer, to redress someone's harm after being fired, bought them a new car as part of the settlement because they lost their car because they couldn't make car payments. At a conference that I attended, the labor board's general counsel said that if an employee loses their home because they were terminated, the employer might have to buy them a new house. That is the kind of stance that internally at the labor board they're taking toward this rule. So you're not just talking about back pay, reinstatement, you know, the normal kinds of remedies. It could be somewhat crazy. Another comment at the conference I was at a few months ago, the assistant general counsel said that employees do not have to live a, quote, austere life. So if they get terminated, someone said, well, could they go to Vegas to go see a concert and, you know, be spending money? Like they can't be complaining about not having any money, losing their car, losing their house, and having the employer buy those things back for them. And their response was, the employee does not have to live an austere life. They can go and spend money if they want to, and that's not going to be held against them. So the potential here could be pretty broad. And this is something that's new, that the labor board remedies have basically traditionally since 1935 been confined to reinstatement and back pay. And you post a notice. So we're talking about a lot more here. What the labor board did not do in that case was allow for attorney's fees. So employees and unions don't get attorney's fees. And they didn't allow for emotional harm. So someone says, you emotionally harmed me. If anyone here has been involved in a discrimination case in court, those kinds of cases involve emotional damages on top of any monetary damages. So at the labor board, it's confined to monetary damages, not emotional. You don't have to pay the other side's legal fees. But it is now more expansive than just back pay and reinstatement. So there's a lot more on the line these days if you're facing a claim of protected activity retaliation. So here's what I think at least is a good example of what can be now seen as concerted. So concerted generally means two or more. That's the dictionary definition of concerted. But this case called Miller Plastics, it was issued at the end of August. It involved an employee who, when COVID first came around, said during a group meeting, this is all he said, we shouldn't be working. He didn't form a group of employees. They didn't march on the boss with a petition to say, we all are going to go on strike unless you buy us masks. He didn't, get employees to strike the employer all at the same time. All he says, we shouldn't be working. Labor Board said that's protected because he was invoking the group we by using the word we, not just himself. This wasn't a quote individual gripe that's unprotected. So if you have a group meeting and someone says we shouldn't be doing that, we should get paid more, we should be able to work remotely. Why do we have to come into the office? These are all we, and everyone else is sitting there silent. That could be group protected activity. And if that person gets fired around that time, they might have a claim. Or you tell them, you can't talk like that during a meeting. That can be the basis of the labor board charge. Other examples that we've been thinking about internally, not being able to work remotely. I just said that's I think a pretty good example because that's a policy that applies usually to more than one person. Complaint about pay equity, especially gender pay equity. The ladies aren't getting paid the same as the men for this job. Well, even if an individual is saying that, that's going to a group concern if there's multiple women in the office. Safety procedures, that also is something that can apply to the whole group. There are several cases, at least two that I know of, that are going through or pending for the NLRB about employees wearing Black Lives Matter pins at work. One is a public case that involves Home Depot. So these are customer-facing retail jobs. The labor board is taking the position that is a group complaint. That is something that relates to working conditions, because it touches on discrimination. So there are issues now, political issues, or that most people would see as political issues. The labor board might say, well, we think that's related to work. That's a protest against working conditions, not political. And then you'd have to address that with the NLRB. So got to be careful out there with protected activity. I could do hours of a presentation about picketing, hand-billing, sympathy strikes, but I wanted to touch on the specific issue that we have been seeing cropping up in our office, where employees seem to have more of an awareness of their labor rights. Now, in this room, union building trades employees know about their labor rights. Their stewards, the business agents know about the labor rights. So this isn't going to be brand new to you. You don't see Scabby the rat really sitting outside of corporate buildings because there's a protest of office employees. But what we really have been seeing is a uptick in what are called sympathy strikes, which is really the technical term for someone honoring a picket line, which I'm sure most people here are very well used to. And how to deal with that. What are the ways in which the labor board would allow you to deal with what's going on if someone is honoring a picket line? So some rhetorical questions here on the slide, but the answer really is no. Can your employees honor a picket line? Yes. Does it need to be another IBW local? No. Does it need to be another building trades union? No. Does it have to be a union affiliated with the AFL-CIO? No. A individual employee, not the union, individual employee has the right to engage in a sympathy strike, to honor a picket line, with limited recourse for the employer if they want to honor the picket line. Sometimes you could avoid the issue if there is no actual picket line in place. And that's where some of these technical definitions of what is a picket line and what's not a picket line can matter. But if your employees, want to honor a true picket line, they have the right to do that under federal law. So picketing is your traditional form of walking around in a circle, normally near a gate, an entrance, some sort of entry point with signs, they say so-and-so on strike, or whatever employer is unfair, or they don't pay area wages, area standards. Picketing creates this physical barrier so that people have to cross it. So what the labor board has importantly said, though, things that are not picketing. A group of guys standing next to the inflatable Scabby the Rat is not picketing. Handbills, flyers, shame on banners, those are not picketing, as that term is legally defined by the labor board. There's technically no picket line to cross if there's just a rat. No picket line if there's just a banner. No picket line if they're just handing out flyers. That's not a legally defined picket line. Now, if an employee or a group or the union takes a position that they're not going to cross any sort of line, that gets very technical. But the labor board in a case last year said that the rat, the inflatable rat, is not a quote signal picket, like a fake picket. So a inflatable is still really very well protected under labor law and not seen as a true picket line. So like I noted before, employees seeing a picket line or just knowing that there's a strike going on at some facility have the right to engage in a sympathy strike. The labor board, where they basically go on strike in support of the other fellow striking workers. They don't have to be associated with those workers at all in the same union or anything like that. The labor board actually gives employers a little more leeway to respond to sympathy strikes than other, primary strikes by employees. What this, I highlighted, bolded, underlined may in this sentence on the slide because it's very important. It's very dependent on the facts and the circumstances, but employers generally have a more robust right to replace employees who are just engaging in a sympathy strike and not a true strike, primary strike against you, or against, the other employers or chapter employers, because, there's a negotiation underway. But it really depends on the nature of the strike and whether that one person or group of employees truly affects your business in a way that's more than just day to day. We can't work today because they went on a strike. It has to be more than that. You're going to lose a giant account, something like that. So that is not a decision you should make lightly to replace people who are honoring picket lines. I'll tell you, candidly, in most cases, you won't be able to. But, if you consult with counsel, you may have a way to address sympathy strikes. I'm going to briefly note that the labor board, in the same light as I talked about with the DOL's Davis-Bacon regulations, is potentially issuing a rule that would go into effect in February that would allow for more employers to be defined as joint employer. So you, even though you had nothing to really do with the dispute, could be ensnared in a dispute for unfair labor practices or even collective bargaining as a joint employer, you and the general contractor, you and another subcontractor bargaining with the union over terms and conditions of employment. And that could be because, your supervisor on the ground ends up supervising, I don't know, employers, laborers that aren't employed by you. So now you are the joint employer all of a sudden with the true, W-2 employer of those laborers, something like that. You could get dragged into other disputes is the key takeaway if this rule goes into effect. And right now it won't go into effect until February, but we'll see what happens. That also could be enjoined by a court. All right, my last topic here is withdrawal liability. And so that is the kind of liability when an employer leaves a pension fund, only the pension fund, not any other kind of fund, health and welfare, vacation fund, severance fund, whatever it may be, just pension. When withdrawal liability occurs, it's usually in the millions of dollars. It depends on how many employees you contributed it for into the fund, how much funding the plan has. Some things are within your control, some things are completely out of your control. But withdrawal liability usually has a big price tag. Some examples of when this could be triggered is when you sell your business, or somehow you're not doing union work anymore, you're not contributing to that pension fund. It also could be just because of a downturn. There could be a partial withdrawal from the pension plan if your contributions go down by 70% or more. There is an exemption for construction employers. But the fact that I'm talking about this today, and there's all this text here on the slide, it is not as simple as saying I'm engaged in construction. I am a construction employer. The exemption, though, is very important. If you do qualify for this exemption, that means that if you have a downturn, if that would normally trigger a partial withdrawal, or you cease work for some reason, you don't generally owe withdrawal liability to the pension fund. So it's extremely important, and the law, the exception comes from the recognition by Congress that there are upturns and downturns in the construction market, and they don't want to have construction employers penalized simply because there's a downturn in the market. Now all of a sudden you're not making contributions. Now all of a sudden you maybe have to go out of business, and you owe this withdrawal liability. That's why there's the exemption. So here's the definition from the National Labor Relations Board of what it means to be in the quote building and construction industry. There are two key terms that I'm going to highlight in the next slide here, is that the work has to be done on the building site. We're not talking about prefabrication work. It has to be something that is forming, making, or building a structure. And I highlighted here that some telecommunications work is not going to qualify for this type of exemption. So if you're planning on thinking I don't need to worry about withdrawal liability, but you are only doing telecommunications work, you may have an issue. And I have an example here out of New York where a arbitrator, and these disputes end up before an arbitrator under the statute. A company dissolved. It was a subsidiary of a larger company. So it stopped contributing to Local 3's pension fund. That triggered a withdrawal from the pension fund. The pension fund assessed withdrawal liability. The company said, well, we qualify for the exemption. We are a construction employer. The arbitrator ruled that was not the case. So running wire, drilling wall anchors, connecting cable devices. This is for someone who did work for Time Warner Cable in New York City. Was not quote forming, making, or building a structure. Not performed in connection with new construction. These were already constructed homes. These are residential homes. And so because of that, there is a $13 million award to the pension fund against that employer because they did not qualify the exemption, although they argued for that. And I assume they had planned on being covered by the exemption and not having withdrawal liability. So if you are facing a downturn, if you are simply in a kind of line of work where you think you may not be, quote, forming, making, or building a structure, you should be very careful about your pension fund contributions, and if some sort of sale of the business or downturn could trigger a withdrawal. With that, we have a few minutes remaining, and I leave any questions that you may have. And thank you for your time.
Thank you, Andrew. That was great. A lot of information to digest. Everyone does have the ability to unmute yourself. So if you do have a question, feel free to speak up. This presentation is going to be recorded, or is being recorded. So if there's anything you need to access, it will be on the chapter's website. Hearing no questions, Andrew, really thank you for your time and your presentation. It was much appreciated. And I hope everybody has a great holiday season and stay safe out there. We'll catch you next year for our next Industry 30. Have a great day.
Aloha.